Welcome, everyone. I'm Kara Griffith, the President and CEO of Tax Analysts, and I'm pleased that you've joined us today for a discussion on transparency in tax administration, where it started for tax analysts and where we see it going in the months and years to come. Since our founding, we have used open records laws and litigation to bring transparency to tax administration nationwide, and we are proud of what we have accomplished in the last half century. From our first lawsuit that forced the IRS to disclose private letter rulings for individual companies, to our recent efforts to obtain and publish state tax auditor training manuals, Tax Analysts has fought to give taxpayers the information they need to comply with the tax law, to hold their tax authorities accountable, and to help ensure that similarly situated individuals and companies are taxed similarly. Along the way, we've set precedents that have increased the access of all citizens to government records. Today, I look forward to an open discussion on the topic of transparency and disclosure. It's one of my favorites, and I hope that you'll join the discussion with your comments and questions. Today is the 6th in Tax Analyst series of public discussions that we call Taxing Issues. We launched the series as part of our 50th anniversary celebration, and through it, we are bringing the tax community together for bipartisan discussions on the future of tax policy with leading policymakers and experts. With COVID-19 continuing to threaten the health of Americans from coast to coast, we will hold these discussions in a virtual format for the foreseeable future. But we welcome your feedback on how we can make them more interactive. You can send your feedback to events@taxanalyst.org. And now on to the topic at hand. Tax Analysts was founded in 1970 to foster a free, open, informed discussion about taxation. From the start, we have always believed that transparency is vital to a dynamic debate on tax issues. 48 years ago, we filed a Freedom of Information Act suit against the IRS, seeking the disclosure of letter rulings and technical advice memorandums. We ultimately won, and in 1976, that disclosure was codified in what is now Section 6110 of the Internal Revenue Code. But I should acknowledge that we needed to launch 3 cases over 3 decades to achieve in reality the public disclosure of IRS letter rulings and technical advice memorandums. Our goal has always been simple: to help improve tax administration by making available to the professions, to the press, and to the public the internal documents that constitute the IRS's working law. We believed that making this body of law available to the public would help tax professionals sharpen their advice to clients, promote the public scrutiny of IRS actions, increase the IRS's accountability for its decision, and end the information monopolies that large accounting and law firms once enjoyed. For many years, large firms and accounting firms had, through their own cases, assembled private collections of letter rulings in their own libraries. Taxpayers didn't have access to those libraries. We also thought that the public disclosure of rulings and technical advice would push the IRS to maintain a uniform position on tax issues as it provided guidance to taxpayers across the country, and that public scrutiny would help drafters of rulings, or regulations or laws for that matter, to resist pressure for inconsistent application of the rules. If you could bring up slide 1. In addition to letter rulings, tax analysts over the years obtained public access to general counsel memorandum, technical memoranda, actions on decisions, and numerous other sets of documents. Courts across the country determined that these documents were of vital public concern, and that their release would not harm the decision-making process. Not surprisingly, the courts determined, in a response to an IRS effort to maintain secrecy, that the IRS even had to disclose a document that took less than 2 hours to research and write, but otherwise constituted chief counsel advice. We'll talk about it a bit later, but the 2-hour rule was one of the more questionable arguments the IRS made to keep its working law secret. And we didn't stop with demanding transparency at the IRS. We demanded the same of state taxing authorities, and we have brought cases in several states. But transparency, and in particular disclosure, doesn't come without a downside. Some members of the tax community argue that the ultimate result of disclosure is simply less guidance from taxing authorities. So we'll have to ask ourselves, is the risk worth the reward? So to provide insight into our efforts and to discuss the implications, I've invited Con Hitchcock to join us. Con is the principal of Hitchcock Law Firm, and he has represented tax analysts in numerous FOIA cases over the years and other open records litigations, both in state and in federal courts. And as I noted at the outset, we welcome your questions. Thank you to those who emailed questions in advance. During the event, please use the chat feature to submit your questions. I will get to as many of them as time permits. Con, welcome.
Thank you, Carrie.
Let's start with a little bit of background. How did you first learn about tax analysts?
Well, it goes back quite a ways. In 1974, I was a law student working for a law firm headed by a fellow named Bill Dobrevere, who was the initial lawyer for tax analysts and advocates and the other groups that Tom Field set up. And Bill had just won this major case about getting disclosure of private letter rulings. And the IRS was resisting, and there was litigation going on in another court at the time. But that first introduced me to the things the tax analyst is trying to do and the importance of trying to get as much guidance as possible. I mean, the one thing that always strikes me, particularly this time of year when I'm looking at my personal tax returns and struggling to get through TurboTax pages, is how complicated the system is and how important it is to get whatever guidance one can to try to get to the right answer. I mean, as you know, our system is based a lot on voluntary compliance, people wanting to comply, people doing what they can to comply. And that really depends on knowing what the law is, knowing what the guidance is. And that's why I think what Tax Analysts is doing is so important at the federal level and now more so in recent years at the state level.
You know, it's true. And it's hard to think about now because I don't think there are many practitioners well, there's at least a new generation of practitioners that don't know a world where they didn't have access to private letter rulings. So I think it really, at the time back in the 70s, it was monumental that Tom Field thought these documents should be public and that everyone should have the same access to them. So it really, I give a lot of credit to Tom for his vision and then for coming up with an organization that could follow through on it. Can you tell us about the first couple cases, like going back to the 70s? Can you tell us, sort of how some of those cases came about?
Sure. One of the key principles that, and I heard Tom Field say this, if I heard him say it once, I've heard him say it 24 times, is that secret law is an anathema, that government agencies should not have secret law that they know about, but you, a member of the public, don't know about. And what is important also is that the public have access to an agency's working law. What are the principles that the agency applies on a day-to-day basis? And it doesn't matter what you call the particular form of guidance, whether it's memorandum or advice or something else. If it lays out the principle that these are the principles that we apply, this is how we analyze an issue, at least at the staff level, it ought to be made public. It's interesting, there's a different perspective. When I talk to people at the IRS or at state agencies and say, well, you ought to make this type of document public. The response I get is, oh, but that's just an informal opinion. Hasn't been approved by 3 layers of supervisors. It's not suitable for framing. You really don't want that. That's not that much value. My answer to that is, as a practitioner, I want to know whatever the law is and whatever I can use to help the client. If I'm wrong, if I'm interpreting it wrong, if the agency doesn't want to follow that advice, well, opposing counsel will certainly tell me, and someone who wears black robes and wields a gavel in a courtroom will also tell me. There's no shortage of people being able to say, no, you're not right in this case. But I think having a sense of how things work is very helpful. And to the extent the information is out there also, if there's nothing that helps you or nothing that hurts you, that's important to know as well.
That's a good point. It's funny. I recall I was at a conference at a state. I will not disclose the state. And I was having a conversation with someone from their Department of Revenue. And he said, if I have to make all of these letter rulings public, then we have to get it right every time. And that was it really struck me at the time. And, first I was a relatively young reporter and I thought, well, that's just the most ridiculous thing I've ever heard. Of course you have to get it right every time. But the reality is that it's difficult. And I do think that there is that fear that you've got a multitude of people, you have an organization as large as an IRS that is trying to actually get it right, and things fall through. And so I understand it, but I 100% agree. The information should be out there. The law at the end of the day is not the IRS's law. It should be the public's law. And so the first cases were truly instrumental. So let's go. You were involved with the tax analyst case that made its way all the way to the Supreme Court. Tell us about that case.
Sure. And I think it's a good illustration of how much the world has changed over the last 25 years, particularly with the internet age. One of the things that tax analysts like to do, because it is so thorough, is get tax opinions from federal district courts, the trial courts around the country. There are 94 of them. Cases start there. And it was very difficult doing so because you had to call up the clerk's office in the District of South Dakota or the Eastern District of North Carolina or whatever and say, I'd like a copy of the court's opinion in such and such a case. Hopefully you had a docket number. And usually if you could get someone on the phone, they tell you, well, it's 50 cents a page. You say, how many pages is it? You'll have to send us a letter. All right. So eventually, you might get the document. I mean, the lesson reminded me of something a former colleague of mine said when he taught law school and tried to teach people litigation. He asked this question: how do you appeal an adverse ruling of the clerk? And the answer is, of course, you don't. You have to work with the clerk. And even if you get it right, you send in your 50 cents a page and so forth, who knows when they will get to it? It's not front door stuff. And by the time that you get to it, the Court of Appeals may have ruled in that case. Anyway, Tom and Bill came up with this idea that there is someone who is a party in every single tax case in federal district court, the tax division at the Department of Justice. So why don't we make a Freedom of Information Act request to the tax division for all district court opinions when they come in? The Justice Department said no. We brought the case, started the trial court. The trial court said, no, these are court records. These aren't agency records. We went to the Court of Appeals in DC. The Court of Appeals said, oh, these are agency records, all the hallmarks, Justice has them, they control them. And then the Justice Department appealed to the Supreme Court and said, don't make us do this. And the case was argued. The court was really concerned. I remember sitting in the courtroom about what are the implications of this? And the question kept coming up, and we dealt with this during the preparation for the argument. Well, suppose somebody wants to get a copy of Attorney General Biddle's biography and it's in the Justice Department library and wants Justice to make a copy of all 317 pages and send it to them. Is that going to be the result if you people win this case? And there were answers to that, like in the real world, that's probably not going to happen, but let's talk about these decisions. Anyway, long story short, the court ruled 8-1 in favor of tax analysts. And what tax analysts had to do was work out an arrangement whereby once a week, someone would go down to the Justice Department. There'd be a stack of this week's district court opinions, bring it back over to Falls Church and let the reporters have at them. It's hard to believe now when you look at the PACER system for getting court records and how everything is, but that's the way it was back in the 1980s. And another area where tax analyst was really pioneering. I mean, sometimes you have to ask yourself, okay, if I can't get this document from the IRS or this agency or that agency, where else can I get it from? Are there other sources? Right. And I think this case illustrates it well.
Yeah, that is an interesting case. And, the interesting thing, sidebar to that, is that in many ways, we still go through that with the tax court. Well, we can get opinions from the tax court. If you want any part of a docket, it's nowhere near as simple as going to the PACER system and finding everything that you want on a given docket. You still have to go down to the tax court. You still have to go to the library. You're still scanning. We have contemplated still having that staff that goes down to the tax court every so often and gathers stuff up and scans and brings it back to Falls Church. So, some things change and some things we're still fighting to this day.
Yeah, it's interesting. I mean, because in many respects, and I worked on this with other reporters in years gone by, court records are public documents. Mm-hmm. I mean, if you're going to sue to try to get a refund or whatever else, you are placing the issue in dispute, and the public has an interest, not in your situation so much, but how the court decides these issues. Yeah. And that's important. And that's why it's so difficult in many cases for judges to close a courtroom or to keep documents under seal. I mean, there are obviously legitimate privacy interests, trade secret interests, those sorts of things, narrow issues that you can try to preserve and protect. But generally, it should be open to the public. It's a matter of, the Supreme Court said about 40 years ago that, I mean, courts are part of government. There's an interest in how courts do their business.
Right. No, I agree 100%. It is really interesting, and the tax bar continues to try to work with the tax court on how we can make a little more transparency there. So let's move on. I have a bunch of questions and they all sort of overlap, but let's move on to sort of the idea of themes, because I think that when we go to that, because one of the themes that you and I have talked about is taxpayer privacy and the importance of taxpayer privacy across the board, but in particular when we are trying to get documents. Talk a little bit about, if you would, on how you've seen taxpayer privacy treated by courts, by the IRS, by states as well.
Well, I think it's no secret that everyone takes taxpayer privacy very seriously. I mean, anybody who opposes taxpayer secrecy, please raise your hand. No one? No. Okay.
Right, no one.
It's as in so many other areas, a matter of striking a balance and trying to, and it's difficult also, and I know agencies feel concerned about that, and we've dealt with this in some of the state cases that we've talked about. The IRS and various state laws have provisions on the books that someone working at a revenue department of the IRS cannot disclose taxpayer information without a risk of criminal liability. Now that makes perfect sense in many contexts. As for example, you don't want someone who was working as an examiner being able to use information to slander someone or blackmail someone or that sort of thing. And I've seen one or two cases, tax notes has reported, where you've had people on the inside. But in some of the cases, and we'll talk about later on, I think the one in Kentucky, that was the one the Department of Revenue kept raising. If we make a mistake in disclosing these rulings, we could be perp walked out of the building. Well, my answer, that's really not going to happen. And as far as criminal liability, you need intent. These statutes, like the federal statute and the state statutes, you must intend to invade someone's privacy and disclose something you shouldn't. I think one of the keys in this area also is having some kind of template where there's, you know how information is supposed to be disclosed, how it fits in. And also, I think if you have the knowledge that what you as a lawyer or accountant or staff person in the IRS or agency is writing, if you know that's going to be made public, yes, that will affect the way you write it. You might not provide as many fulsome details as you would if it weren't going to be the case. But on the other hand, that promotes some degree of discipline in the writing process, and it may approach some degree of uniformity. But I can understand why some state agencies in particular, and the IRS maybe, when looking for the first time at the challenge of disclosing a document, would say, we better get this right, and we're concerned if we don't get it right. So I think it's an ongoing issue. It's important, and it's a matter of balancing. But I mean, there's one case where they're working on the state side with your folks there now, where the Department of Revenue said, these letter rulings, well, there's taxpayer information in them, so we're entitled to withhold everything. We're fighting that one.
Yeah, that one's worthy of being fought because it's too far. And we should actually, let's move on to the Kentucky case, because I want to come back then to the initial opinion that we got from the Franklin County Circuit Court, because that judge wrote a really nice opinion and did a great job of going into the balancing test that's necessary for protecting taxpayer privacy, but also allowing disclosure and all of the good that comes from the public disclosure of the Department of Revenue's final rulings. So I'll kick it over to you. You can give us some background
Sure.
on that Kentucky case. That was a fun one.
Yes, for background, the Kentucky legislature passed a law that says anyone who wants to can request a letter ruling from the Department of Revenue in Kentucky. And a lot of the letter requests that come in are people who are disgruntled with a particular adjudication and may write just a one paragraph letter saying this is wrong. By the time we got involved, we were working with some local practitioners in Louisville. There were about 700 of these letter rulings that had never seen the light of day because of concerns about secrecy and taxpayer secrecy and being arrested and headed over to the Franklin County jailhouse in downtown Frankfurt. And what happened is you had two categories. You had those where, well, the statute says if you don't like the advice that you are given, you can take an appeal to the State Bureau of Tax Appeals. If you do that, the documents are all public, your name is public, the issue you're raising is public. The other half of the documents are those where the taxpayer says, okay, all right, you've told me what the answer is, I'm not going to do anything else. We wanted both categories of records. The Revenue Department said, oh, those records where there was an appeal, well, you have to contact the Tax Bureau and get them there. Our records are not particularly well organized here and we can't process them for you. I should add, even though the department was a party in defending each and every one of those cases, they claimed that the records weren't well organized enough to be able to respond. And for the others, there was no appeal, those still contained interesting discussions. What happened is the judge gave us, ordered both categories of records disclosed with a comment that surely they ought to think a little harder about their record keeping and getting it a little more accurate if they don't know where the location of various records they're actually litigating. And so we took it up and we actually, I remember in the Kentucky Supreme Court, held in the state capitol, one of the judges did ask the question you just raised, Kara. If we rule in your favor, doesn't this mean there will be less disclosure? And won't the world be a worse place as a result of that? And the answer is no. And what happened in Kentucky, I think, is a good illustration because what happened there is they adopted a template, as many other state revenue departments have done. You know, there's
We've got
you can do that, and it works.
I think that's right. You know, and I think that the balance is, it's so important to try to get the right level. You know, the Kentucky case, ultimately we won. It took forever and a day to get there, but I think that we did get a good opinion at the end, and we really got some nice opinions along the way that laid it out. And of course, then there was the subsequent where the legislature tried to come in at the last minute and sort of quash the entire thing that we had done. And thankfully, that went by the wayside, and our opinion still stands. But it really shows that it can often be a multi-level fight of trying to get disclosure and then keep it.
Yeah, I think it's important to note too, part of what we're doing is changing the culture. If no one has previously asked for these documents, they're not going to think about disclosing them. And there's also, you lay that on top of the concern about taxpayer privacy, and that's a wall that you have to break through. Yeah. I mean, I think, you know, in the years that we've been dealing with the IRS, the relationship has changed. A wise man said years ago, the Freedom of Information Act at the federal level forced federal agencies to organize their records a lot better. Because Congress is not going to give agencies millions of dollars to handle more FOIA requests. Right. So it's an internal management question. Right. And since 1996, Congress mandated an electronic reading room, the FOIA library, where one can get access to a lot of these documents. And I think it's true, at least, you know, I've been, you know, working with you and with your colleagues for about the last 20 years, I guess. I think we have a relationship with the IRS where we can call up and say, we have a question. We're not sure about this document. Why are you doing it this way? And you and I have gone down to the headquarters building and talked with people and raised questions that our readers have brought to us and said, how come? And we can have a dialogue. We may not always agree, and sometimes they will be persuasive. And sometimes we'll say, okay, thank you very much. And, you know, I've had other times working with your reporters on a request where I will get a call and somebody said, you know, we're here at the IRS, we got your request. We're not sure exactly what you want. Do you want just the information for headquarters? Do you want headquarters plus all 23 regions? How do you work it? And if we give you headquarters only, you can have it this week. If you want to go through searching for all the regions, it's going to take several months. And that's really important, I think, from a reporter standpoint or publisher standpoint, to sort of be able to use the statutes effectively to try to get the information. So I think, the IRS knows who we are. The federal government, Congress has forced a lot of transparency on federal agencies. Some of the states, well, they're a little slow. Although, to give credit where credit is due, ever since we started going after an attempt to get these field audit make available to help with compliance, most agencies were pretty good about it. They were willing to give them. If they balked, there was a state Freedom of Information Commission or some internal state body that looked at this issue a little more broadly in terms of disclosure rather than simply from a tax or revenue perspective. And we were able to get, I think, 40 state manuals
Yeah.
from 40 revenue departments, and we only had to sue once.
That's
which
right.
we'll get to that.
Yeah, that's right. I think
so I do want to give credit where credit is due.
That's right. You could tell, even in the time that I've been around, the difference in how we used to work with the IRS and how we do now. And we have a much better dialogue now and are able to have those conversations, tailor the FOIA request if necessary in order to really get the desired documents that we're trying for. Because oftentimes, even when I was a reporter, you would know in your mind what you were looking for, but it was really hard to sometimes describe it. And so figuring out what is the language that we should use to describe the proper request, and then how do we get to the result that we're looking for, keeping it as minimally burdensome as possible on the IRS. So I think having that open dialogue really, really helps. And the states have had less time to think about it. And so we're getting there. We did have a tremendous response to the audit manuals where most states said, yes, these should be made available. The one, which we can talk about in a second, that we did legitimately have to fight for, and there were some other issues that we noted with the audit manuals, and it sort of goes back to the taxpayer privacy concept that there should not be confidential taxpayer information contained in an audit manual. The states should take that note that they should strip confidential taxpayer. No real world examples should be used in your audit manual. Go ahead and use XYZ Corp rather than an actual name. But let's go ahead and talk about Illinois, which was was a recent case and a nice win. It was the right decision, I will say, from the court that they should have released that manual. It was most other states were doing it. It is not something that should be confidential. These audit manuals should be available to the public. But talk to us about that case.
Sure. It started out as all these others start out. One of your researchers on staff wrote a letter to the Illinois Department of Revenue and said, we'd like to get a copy of it. And they came up with every excuse that we've seen before. Taxpayer privacy, that's the major one. The other one, another favorite, is that it will disclose methods that we use and lead to circumvention of law enforcement. And it's incredibly burdensome. That was the third argument. Illinois does allow agencies to opt out of disclosure if the request is burdensome. They said this is burdensome because it's 3,200 pages, which is roughly the same size as some other manuals that we have gotten, bigger than most, I would concede. So we had to litigate in Springfield, Illinois. We had the good luck to find a law firm there, a lawyer there who represents Illinois newspapers and publications, who knows the stuff backwards and forward. And we went out there and argued. And what they told us at the end, I remember talking with the fellow who's the senior staff person. He said, look, we don't want to disclose anything that would show what the thresholds are when we're going to come in with an enforcement action. And we said, fair enough. We have agreed not to seek information of that, allowed you to redact that in other situations. And it worked out. We won the case in the trial court, and the Department of Revenue took an appeal, and the Attorney General's office got involved further at the appellate level, and they decided to give us the material with some line deletions. They delete stuff like images that would appear on your screen if you're an examiner in the Department of Revenue, things like that would be internal. So it did work out. Someone told me, I think in this case, he said, you have to remember sort of like the audit divisions, they're not really into disclosure. Okay. I make no judgment about that, but in any event, and I think it's good. I mean, again, it goes back to the principle we talked about at the top of the hour. Most taxpayers want to comply. I mean, if you're a lawyer or an accountant with a company and you know the auditor is coming, there is value in knowing what they're going to ask you. So you're not going to have to say, oh, I'm going to have to get that from the home office in St. Louis or whatever else. It makes the process move more efficiently. And that's all to the good.
No, absolutely. Do you remember the, because this one we didn't end up having to go to court over, but do you remember the California where, and this was it stemmed from an article I was writing, and I realized that there was a reference to a form, and I wanted a copy of the form, and so asked California for the form, and they said no, and I was appalled. Like, it's a form, it has a form number. You have to produce that.
Right.
It was all. This is a while ago now.
I remember.
Do you remember? You remember that?
Yes. It was a form, and you would fill in information. It wouldn't tell you whether you had triggered the threshold for an audit or for an enforcement action. And we worked with a local lawyer in Southern California, and sued the Franchise Tax Board. And after a lot of hemming and hawing, but before they had to get into any serious brief writing or anything of that nature, they said, okay, here it is. And we got it. I think Tax Analysts has now sued in half a dozen to a dozen state courts for a variety of information. These manuals are one. We've got another case going in Indiana at the moment where so far we finished second to try to get information, and we can talk about this, information about bids that Indianapolis and local authorities made for the Amazon headquarters 2 building. I know Tax Analysts and other journalists have been very successful in getting a lot of the losing bids and learning various interesting things about these taxpayer economic incentive plans. But Indianapolis and the state agency that we're suing, that they've held out, and we're fighting on.
Yeah, let's talk about that case, because that's a really interesting one. And honestly, the idea, this is something that we have delved into before, is trying to get information on these large incentive deals, because it truly does come down to how is the state using its money, and these should be subject to scrutiny. So give us a little background on the Indiana case.
Sure, it's interesting. Indianapolis, and the city of Indianapolis and the city of Gary both made bids for Amazon's HQ2. And there's a state economic development corporation, the Indiana Economic Development Corporation, that provides assistance, and in terms of various grants and other things consistent with state law. Gary lost in the first round. Indianapolis made it to the second round of 20 finalists. One of your reporters who was working on this, and there were a number of cities that you were covering, as I recall, was able to get a copy of the city of Gary proposal, which showed that the state agency was willing to spend or to commit $1.5 billion to help the city of Gary. Now, there's a question that some Indiana residents may wonder, well, how much would they be willing to put on the table for Indianapolis? And that's something we pursued. And the argument that the agency made, the corporation made, largely was that, look, there was no deal. We disclosed the agreements where we actually sign a deal, where things have progressed to a point where we know how many jobs are going to be provided and that sort of thing. But these cases that don't get that far, the statute doesn't reach these sort of final offers. And, in a case like this, the Indianapolis proposal was just an initial submission. It didn't go through 5 or 6 rounds of back and forth. So therefore, it's not the sort of final offer that you would be interested in. I would say to that, in talking with your colleagues, there still is a lot of interest in terms of how a state agency is proposing to use public resources that, if they go for tax breaks, can't be used for other things. And the Amazon HQ2 example is particularly interesting. Given the work Tax Analysts has done on economic development, the losing proposals from Maryland and New Jersey were both disclosed. Maryland, I mentioned, because it's right next to Arlington, Virginia, that got one of the 2 headquarters, and New Jersey, because it was right next to New York, which was the initial winner. And they showed that New Jersey and Maryland were willing to spend twice what Arlington and New York City were willing to spend. I'm saying spend in terms of provide commitments.
Right.
So does that make sense? Is that good policy? The other thing that we learned along the way from looking at the studies is that Indiana is spending twice as much as the neighboring state of Illinois in terms of creating jobs. There are metrics that economists can look at. Does that make sense? Now, one may say, well, in Indianapolis, we're not Chicago, we can't compete. And so therefore, yeah, we have to spend money. And I've heard that, this is not a direct quote, but I've heard that from other people who say, yeah, we have to spend more. So, but it's a question, is this a good use of taxpayer resources? And the Amazon case certainly provided a wealth of information, both for those that were willing to, who did win, and for those that didn't quite make it to the finish line.
Yeah, it's one of those areas that I think is ripe for investigative journalism, because there is a ton of money that is spent. The public often knows nothing about it, and it is difficult to get these documents. I used to blame the fact that a lot of times you were trying to obtain documents from a local economic development committee that met on the third Wednesday of every month. And so your chances of getting someone and actually talking to a human about what you were looking for were pretty slim. And so it certainly is an area that is ripe for investigation. And I'm thrilled Lauren's done a good job, and we'll keep trying to see what we can get.
Yeah, and in Indiana, I would say that there's sort of a mystique that you can't challenge us, you can't question us, that, we know what's done. And if information bleeds out somehow, well, no one will ever want to build a plant in Indiana again. I think that's an exaggeration. The accountability issue is still there. These are public resources that if they go for, building a plant that doesn't provide the number of jobs they have, well, what's going to happen? And interestingly enough, we were able to, the Hoosier State Press Association, the Hoosier State Press is not Indiana, filed an amicus brief pointing to a number of situations where there had been contracts signed and grants made, and well, they didn't pan out quite the way that the press release and the signing ceremony and the announcement by the governor and so forth made things look like they're going to sign. So there's a public interest there, there's a taxpayer interest there, and Tax Analysts certainly has been on top of that issue in a number of respects.
It seems like a lot of the times the initial knee-jerk reaction from the government, and this goes across the board, has been that the sky is going to fall. If we grant and disclose this information to you, the sky is literally going to fall. And I think over the years, at least like with the IRS, we've realized, and they have too also realized, that the sky doesn't fall. And sometimes it's finding that balance as to where it is. Because I mentioned in my opening remarks on the 2-hour rule, that kind of felt like one of those instances. It was like a last ditch effort of, well, we can't, how about we try this? How about we say that if it took less than 2 hours, then we get to keep that. And it's another one of those of just desperately trying to hold on to the idea that we can't let the sky fall, because it's going to if we disclose this information.
Yeah, that would also involve some administrative convenience, I'll call it.
Absolutely.
I mean, for the benefit of those who are not into the IRS put out a memo, this maybe 15 or so years ago, which says, normally speaking, chief counsel advice, which comes in a range of flavors, need not be disclosed if it took you less than 2 hours to prepare it. That was an internal directive to people in the IRS chief counsel's office. And we looked at this, well, wait a minute, that would seem to let a lot of stuff out. And the concern was that, if we have to sort of go through these emails, and a lot of it is email, and scrub out any taxpayer advice, that means more work. And that's true. But a lot of the advice that is given can be very valuable. And I remember Chris Bergen, your predecessor as publisher, and I went down to the IRS headquarters, and they showed us what some of these look like. And their argument there was, this really isn't that valuable. This isn't really that great. It's not going to help you that much. To which my answer, I come back to the point which I made before. If you're a lawyer or an accountant representing a client before the IRS, you want to know whatever there is. And okay, so it's not final. Okay, so it's subject to check. But if the advice is wrong, if the interpretation is wrong, somebody will tell us that it's wrong. And hopefully we'll do so in a manner that's published or made available so we understand what the right answer is. I mean, the development of law in the tax field or any other is largely an evolutionary process. It's challenging in the tax law because you have statutes that are written to apply statewide or nationally, and yet you've got millions of taxpayers, every one of whom has a different situation. So one does what accountants or lawyers are trained to do, try to look at the various situations, figure out which most closely relates to my situation, and take it from there. But I digress. Anyway, the Court of Appeals, including future Justice Kavanaugh, ruled in our favor that the IRS did have to make this available as chief counsel advice. We went back down and talked to the IRS about how to implement it. And we tried to work with them to make it as easy to administer as possible. For example, they said, we've got tons and tons of these emails from years gone back. Do we really have to sort of go through and process all of them? That could be a serious manpower issue. And we worked out an agreement to make the stuff available on a going forward basis. Mm-hmm. And, I'm sure it didn't make the IRS happy, but the information is there. Tax Analysts looks at it, publishes it. There may be stuff that's helpful to someone. And if so, that's all to the good.
That's right. That's right. And there may be a whole bunch that isn't, but if that tidbit is useful to one person, then it is useful. We've certainly been challenged by, as things transformed from everything in a written form, on paper written form, to email. We've certainly struggled a little bit with finding the right balance there. And then have documents change names? Is there a new document type that is now in email form? I think that's been, for us at least internally, it's been an ongoing process of trying to figure out and keep track of, are we getting everything that we should, that mm-hmm. falls under sort of the category of chief counsel advice.
Yeah. No, and it's an issue. I mean, I can remember, 30 or 40 years ago, if you're a lawyer in discovery and you ask for documents, the phrase is they will boxcar you. You'll get cartons and cartons and cartons of stuff that you then have to go through and find out which is relevant. Because in any big case, the case often comes down to a handful of documents, right? Where something is said or isn't said. And then as the internet took over and there's electronic discovery, and nowadays everyone uses email rather than writing letters and dropping them in the mailbox. There's a lot of electronic discovery, and I've done that. It's not fun, but instead of 20 crates, they now deliver you 3 CD-ROM discs, and you got to go through and have your set go through. And it's the same process. I mean, there's a lot more that is available, and sort of separating the wheat from the chaff is a challenge, no doubt about it. Yes. But it's the world we live in now. And I wouldn't want to go back to the days of having your office cluttered with boxes and boxes of stuff, 99% of which you will never find useful.
That's right. It was Kentucky initially sent us a bunch of rulings. They were double-sided and stapled. And I will take a CD-ROM any day of the week over 2-sided copies stapled in the upper left-hand corner. What is your sense now of how things are going at the IRS, at the state level? Just talking about email, do you think there is still a lot that we are not getting? Are there still documents out there that we should be trying to go after? Do you think we're gonna have to evolve and find new ways of getting classes of documents that we don't know about yet?
No, I think with respect to the IRS, I think there has been what I referred to a moment ago as a change in the culture. When Congress does mandate that you have to put advice up on the internet where anyone can get it, yes, there may be some initial resistance, but that defines the world that people have to work in. And you have to think about when they are writing documents and recognize that it has to go up. Yes, there may be disagreements, arguments about individual items from one time to the next, but I think things are working better. I mean, the number of cases we filed against the IRS has dropped off fairly dramatically over the last couple of years. I mean, I remember when Bill D'Auberville called me up in the late 90s to say, I got 5 cases going against the IRS, can you help? We're not in that world anymore.
No, that is good.
Of course, we are in a world where Congress managed to pass a tax bill in 2000 that wiped out several of those cases. But so it goes. I mean, the evolution, it's an ongoing process. I mean, Congress cares about what laws what information taxpayers have. The IRS cares. Tax Analysts as a publisher cares. And
Yeah.
that's how you have, the dialogue goes on, the dialogue continues. And, that's why I think Tax Analyst plays a key role as a broker, putting the information out there and having those debates.
No, that's a good point. One thing I wanted to talk about was we deal a lot with redactions. A lot of the documents that come in are appropriately redacted so that confidential taxpayer information is not made available. We've often had to fight those redactions though, because you'll get a page that is 100% black and it's not, everything is blacked out. You can't see anything. What have you seen over the years in terms of challenging redactions? How often is it just overly heavily redacted, too heavily redacted? And then how have you been able to, because we have successfully gotten them to reduce the number of redactions and release additional pages. What's been the most successful arguments that you've been able to make?
Well, a couple of things, and that's an excellent point. I mean, if you get the documents, and let me break it into several parts. If you get the documents in response to your request, and there's a number of items that are blacked out, you have the right to an appeal to higher up in the IRS and perhaps also in a state agency. And you may be able to do better than at that level if you get somebody who's independent, can take a look at the documents and say, I think this goes too far. So that's one method. Another method is, having a conversation with the person who is actually handling the request and doing it. And I've been working with a couple of your reporters, one recently, where the IRS the person who's handling the request is not in the substantive department, has to request the records. And in a sense, that's good because you can talk to them about what the documents have and what are some of the concerns and try to work it through and make, what I tell your reporters and anyone else is try to work with the agency. Imagine you're at the other end. This request lands on your desk. What are you going to do? And if you formulate the request in a manner that makes it somewhat more bite-sized or easier to process, so be it. That makes life easier. It's difficult to the extent that you have people who have legal training where you're told, ask for everything, everything relating to whatever. If you ask for too little, if you ask for too much, they'll tell you. And you have to sort of adjust from that mindset and try to go for it more specifically. But one of the things you can do also is if you in court, and we're dealing this in one of the cases I mentioned a moment ago, one of the state cases, ask the judge to look at the documents in camera and see if they really are 100%. And judges will do that. They're experienced looking at things, and you don't get to be a judge without having some idea of how government works and can see if these arguments are really successful or not. So there are several things you can do in terms of having a dialogue or taking an appeal, having a dialogue, or litigating it.
Yeah, and I think we probably had to use all of those. The in-camera review has definitely been a useful tool because it is hard to know what you don't know. And if you haven't been able to see it, and so then at least if someone is able to see it and make a determination, that does help, and it certainly does. We got one question on whether there's any effort underway to get public disclosure of closing agreements. Tax Analysts has not yet. Closing agreements would have quite a bit of confidential taxpayer information in it. The idea of obtaining settlement agreements and closing agreements has always been something that I have toyed around with. It's always been difficult. There's definitely two sides to the story, but it does seem, because so many cases right now get settled out of court. So having some of these, whether it's at the administrative level and they come to an agreement on an audit, or something actually gets filed but then gets settled, I totally understand that there's a huge amount of guidance that would be able to be had from those two. We've never quite found the right avenue to request and obtain them.
Kara, I have to admit, I just lost audio, so
oh,
I could try to respond to that particular question. Did in fact try to get a closing agreement some years ago in a case that the IRS involving Christian Broadcasting Network, which you may remember founded by Reverend Pat Robertson. And in 1988, Reverend Robertson ran for president. And apparently there was concern that the Christian Broadcasting Network was involved in his political campaign, which as a C3 group, it should not have done. And some years later, the IRS issued a press release and an announcement that tax-exempt status had been revoked for several years, and then it had been restored, and there was a closing agreement. We asked for, what happened is in 1998, that CBN submitted a new application, Form 10423, for tax-exempt status. And it seemed to us at the time, reading the press release and the application together, and they were like within 3 days of each other, that it was a package deal. I mean, it looked like that the closing agreement had been negotiated in connection with the new application for exempt status. And so we requested them. And under the law, closing agreements contain taxpayer information and are not going to be able to be disclosed. However, there's the provision dealing with nonprofits, section 6104, which says information submitted in connection, supporting information submitted in connection with an application for tax-exempt status must be disclosed. So first question is, does that trump the non-disclosure of settlement agreement, of closing agreements? And the Court of Appeals in DC said, yes, if it's submitted, something is submitted in support of the application, then it must be disclosed, even if it's a closing agreement. Case went back, we had to take discovery and to find out if that was in fact the case. We actually took a couple of depositions, got a lot of information, and it appeared that the closing agreement in that case had not been submitted. It was not a part of the new application for exempt status in 1998. So we came in second again. But that's the only case I can think of. You do have the protections for closing agreements because of the concern about taxpayer information. And beyond that, I'm not sure I could offer your listener any more support.
Yeah, it's a challenging one. It's one that I really have wanted to delve into, and certainly did when I was a reporter, and I haven't been able to. We'll have to find the right set of fact pattern to get there. Are you hearing us again? Oh, I don't know. Well, the one thing I did want to talk about before we close out was something that I mentioned in my opening remarks, and that was on the downside of disclosure. And there is an argument to be made that requiring disclosure results in the agencies producing less guidance. And that is something that I know that we've thought about at Tax Analysts for some years. And I would have to say that while I believe the risk is there, it is worth the reward. And ultimately, transparency and disclosure lead to more open tax administration and really better. And I don't always see the downsides to disclosure. But ultimately, to avoid it, you sort of have to get to what Con and I talked about earlier on that culture of secrecy. I used to describe it at the state level, said that it felt like it was a them versus us situation. And you really feel like you've got the taxpayers on one side, you've got the Department of Revenue on the other. And so how do you change that? And first of all, you have to go back to then that FOIA or public records, open records laws are not the solution. We as reporters use FOIA, and FOIA is used in litigation as well. But it's really for the egregious case. It shouldn't be the standard. Agencies have gotten very skilled over the years at utilizing the exemptions under FOIA. And so there's an easy loophole for how do you get out and how do you not have to disclose documents. So we really have to get to that culture of secrecy and say it's not a them versus us. It is how do we encourage voluntary compliance. Now, of course, there's a lot to that, right? So you get to the need for resources. So resources are needed to ensure that guidance is given, it is written properly, as I was told once, it is right, and it is properly redacted. And that's really, that is only one aspect of it. At the end of the day, the solution requires that change in attitude, and the change in attitude has to come from the top. Leadership at the IRS, leadership at these state agencies have to make clear that the goal of their department is not to get the most money out of the taxpayer. It is to ensure that taxpayers are doing their proper duty and voluntarily complying, voluntarily reporting their income, and that similarly situated taxpayers are in fact treated similarly. They do need to remember that it's the public that owns the law, it's not the agency. And publication of an agency's working law is necessary, and it is important to ensure that our taxpayers have confidence in this voluntary system. And at the end of the day, we may need more legislation. Some of these things can't be handled at the agency level, and they can't be handled by the courts. And we have often found that. So the courts are very useful in litigating a dispute, but that dispute has a fact pattern, and we are limited to that fact pattern. We really can't get beyond, and so you lose the ability to have a broad change at the judicial level, because you've got a fact pattern, and that is it. I will say that we have here, sometimes you get to a certain point in a case and it's like, well, should we call it that we lost, or should we keep pushing? And I've said sometimes let's keep pushing, because at least we are going to put some guardrails around Section 6103. And so, what are the exemptions that can be used? And sometimes that has worked, and other times, as Con noted, we came in second.
Can I add a thought on that?
Oh, absolutely.
We're back at technical problems beyond our control.
No worries.
I mean, you're making an excellent point, and I think one of the things, from agencies that may be looking at this is there periodically comes up a movement for taxpayer bills of right, TBORs, and that sort of thing, which agencies may like even less than what we're talking about here. I mean, another point, and this was made in Kentucky, is that one of the advantages of being able to understand how the tax laws work is it's good for business. Businesses may want to know, what is the tax climate in this particular state? Should I open a plant there, or should I look at another state where it may be better? And some measure of transparency makes it easier for people in the state to advise a company. Well, yes, we can do this and we can do that, and other things like that. So it's all to the good.
No, I totally agree. It is all to the good. Do you have any final thoughts on where you see us going? Should we take bets on Indiana?
Well, I suspect there will be challenges in the next 50 years, and in the next year in particular. You're dealing, as you branch more into the state area, and I thank you for introducing me to that, which I was not familiar with before, but there are a lot of interesting issues in state tax. The challenges will be somewhat the same. I think one of the things which I found when I worked for an activist organization early on is for government agencies and companies to realize that you're there, you're going to be there, you're not going away, that you're part of the landscape, and they're going to have to figure out a way of dealing with you. That way may lead to running to the legislature and making sure that you're never going to get any information of this sort again. But people are reasonable, and it can work. And I think, if Tax Analysts is doing the sorts of things it's been doing so successfully for the last 50 years, things will turn out very well.
Yeah, I think you're right. I think that you made a bunch of good points, but people are reasonable. We are here to stay. The state arena as well as the federal arena, we will keep looking. We do rely on our readers. We rely on those in the tax community to help us to determine what are the trends, what are the documents that maybe they're seeing. So I usually do put out a plea to all of the listeners and our readers as well of, reach out to us if you feel like you're being stonewalled on a certain document. We're always happy to look into these things, but we'll keep moving and see what we can uncover.
And I can remember a couple of instances where you or one of your reporters just reached out to me and said, our reader asked us about this. Can they do that? And maybe yes, maybe no, but we're willing not just to sort of report the news, but as I mentioned, if it's a federal issue, we can call up the IRS and say, can we meet? Can we have a conversation? One of our readers has asked us this question. What's the answer?
That's right.
They may have good answers for why they do it that way, in which case we say, thank you very much. That's been very helpful.
That's right. Well, thank you so much for joining us today. This was a lot of fun. It was a little bit of a walk down memory lane for me, but this is a topic that we hold very much close to our heart here at Tax Analysts. And thank you for also being a part of it for the last 50 years.
Thank you, Kara.
Thanks. Thanks, everyone.